Now, when you say cutoff date, is that the same thing as commencement date of the divorce action?
Typically, it could be. Certainly, in this case, the parties had agreed to had stipulated that there was a cutoff date. Typically, certainly in New Jersey, a cutoff date is the date of complaint for divorce, but it's not absolute in terms of certain assets are treated differently than others. For instance, active assets such as a business, the cutoff date is usually an absolute date, whereas passive assets such as bank accounts, stock accounts, real estate is valued closer to the date of distribution, which is usually sometime at the end of the case. In some states, they actually distribute assets all the way up until the trial. We don't necessarily do that in New Jersey, but we try to get as close as possible, especially for passive assets, so that we're taking into account differences in value that are not the result of either party's efforts.
What if Mr. Simkin was successful? Do you think that this would have created a very dangerous precedent?
I don't think so. This is a very unique situation. It's not often that people are bilked out of major assets that they divided in a divorce and realized that there wasn't an asset. So I don't think this has any real precedent. I think that if there really wasn't any money there, or Mr. Simkin could never had access to that money prior to the scandal hitting, then it would be an unfair decision that he didn't get to reform the agreement. Because if there really was no ability to ever remove money, and in this case he actually did remove money to pay off his wife, then he would be harmed. And clearly it was based upon, in that case, both parties' belief that there was an asset that had value that really never existed.
So at the end of the day, what were the key arguments to Justice Evans' decision in this case?
I think the key argument was that, in fact, Mr. Simkin could have taken the money out of the account and that it was available for him to remove. Whether or not it was fraudulent or not, nevertheless, if he would have gone to Madoff and said, I want my $5.4 million or whatever the account balance was, he could have actually taken that money and had it, even though there may not have actually been an asset in the truest sense of the word.
Now, after Mr. Simkin learned that he and his wife had been tricked by Madoff, and he sought to reform the divorce agreement, he claimed that the agreement did not accomplish what the parties' goals originally was, which was to have each of them keep approximately half of the marital assets. Is this just a legal strategy, or is this really something that the court should have considered to grant his request?
I think it was both. I think it was a legal strategy and something that the court should have considered. And I think the court did consider it, but also the greater consideration and the greater evidence was that because he paid his wife $2.7 million or paid her money that came from this account and could have taken the money out himself at that time, it did accomplish what the parties' goals were. Theoretically, if they liquidated the account at that time and both took half, they could have accomplished that at the time of the divorce. And it doesn't seem to have been any evidence to the contrary that couldn't have been done and that they couldn't have withdrawn the money and just divided it equally. Like many other divorce litigants, he made a choice to keep this account and ultimately suffered the wrath of what happened to the account based upon the choice that he made.
Okay, let's talk about Mrs. Blank for a moment. What was her argument that opposed her husband's claim?
One of her arguments was just that money was taken out of the account to pay her. Another one of her arguments was that the agreement had mutual releases in it, releasing any further claims or lawsuits between the parties.
All right, you had mentioned before when we first started to talk that Mr. Simkin's argument that the divorce agreement was based upon, I think the term he used was a mutual mistake. Did the court actually reject that whole process, or did they consider it? Was there any evidence that Justice Evans interpreted in any way, shape, or form that theory and that argument?
From the opinion, it didn't seem like she accepted the mutual mistake argument because she found at the end of the day that there was value to this account as of the cutoff date. She didn't need to get to the mutual mistake argument because each party could have taken the money out of the account as of the cutoff date.
All right. In a divorce agreement, there's often a waiver that each party signs that addresses any claims they may have against each other in the future. What did Mr. Simkin's legal team do to address this? And do you think they could have addressed it differently to maybe have the court have a different decision?
I don't think they could have addressed it differently. I think the mutual mistake argument is a credible argument. It's not atypical. In fact, it would be atypical for an agreement not to have the waivers in the agreement as part of any standard divorce settlement. And in fact, it's usually part of any standard settlement of any lawsuit. It waives future claims. So it's not unusual here. And a mutual mistake seems to be perhaps the only credible argument that he had, assuming that the account was really valueless. Unfortunately, in this case for him, the court found that the account was not valueless. There could have been value as of the cutoff date. Mutual mistake is a very old concept going back to black letter law, probably 50 or 100 years. You learn that in first year law school. It's one of those concepts that allows people to avoid a contract if the contract wasn't what they believed it to be. In this case, unfortunately for Mr. Simkin, there wasn't mistake. At least the court found there not to be mistake because the parties actually could have taken out $5.4 million at the time of the divorce, which is what they stipulated the value of the account to be.
Well, I'm glad you mentioned learning in law school, because my next question is, what is the lesson that we're learning here? What do lawyers need to attend to when fashioning settlement agreements? And does this decision lend itself to a change of how attorneys will prepare and negotiate divorce agreements?
I really don't believe it's going to lend itself to any changes in the practice, because I don't think people in general would question account statements, which is what they had here. They had account statements that said the value as of the date was $5.4 million. People usually rely on account statements. And I would suspect that if people actually questioned account statements, they would not get an admission by the financial institution that they were defrauding their customers. So I think that it was not unreasonable for the parties to rely upon the fact that there was this amount of money. In light of the Madoff scandal, do we tell our clients that they should withdraw their money just in case? I don't think that that's sound advice, and far-reaching. This is a unusual circumstance that Mr. Simkin found himself in.
Certainly unusual is putting it lightly. Well, Eric, I want to thank you for joining us today for a discussion on Judge Evans' decision on the Simkin blank matter. Your insights are certainly timely. Our guest today has been attorney Eric Solotoff, and as I said before, Mr. Solotoff is a partner with Fox Rothschild. If you have any questions on this matter, I'm sure Eric will be happy to hear from you and be able to assist you. Eric can be reached in his New Jersey office. His telephone number is area code 973-994-7501. As always, our audience is also welcome to contact our offices with any questions or comments. Stay connected with us on the web at www.msgcpa.com, where you can also subscribe to our newsletter, Forensics Perspectives. We can also be found on LinkedIn, Facebook, Twitter, and of course by phone. Your topic suggestions for future broadcasts are always welcome. Until our next podcast, this is Mark Gottlieb. Thank you for joining us.
You have just enjoyed another episode of Forensic Perspectives, hosted by financial expert Mark Gottlieb. For questions and/or comments regarding this broadcast, please feel free to contact Mark by phone at 516-829-4936 or via email at msgcpa@msgcpa.com. We also encourage you to visit our website, www.msgcpa.com. The opinions and commentary in the preceding program provided by our host and guests are for informational and educational purposes only and may not be their personal or professional opinion. No accounting, tax, or legal advice is being provided. The information provided within this broadcast is not an invitation for an attorney-client or accountant-client relationship. One should always seek the advice of competent professionals to assist in their specific needs. In addition, this podcast will not be updated for changes in accounting practices or law. As such, one should not rely on any information provided by this podcast. References to resources are provided solely for the listener's convenience. We have not reviewed or verified any information, advertising, products, resources, or other materials mentioned herein. This broadcast is copyright of Mark S. Gottlieb, CPA PC, all rights reserved. Any redistribution or reproduction of part or all of this broadcast is strictly prohibited unless authorized in writing.